welcome to our mock trial. I introduce myself. I am MD Ariful Islam chowdhury and I am a chief leader in our mock trial group. Good to see so many people in our talk. Dear audience and honorable sir, after a few minutes later, our group members also arrange a mock trial. So, it's our request to all to ignore all our shortcomings and all of you please help us to successfully complete our mock trial. So thank you very much to all of you and all of you please enjoy our mock trial episode. Thanks again.
Dear audience and jury, our honorable judge is coming.
Sit down please.
Dear jury, the case number is 12. Now our session is opening.
Dear audience and jury and honorable sir and our group members, welcome to our mock trial and good evening to all and Jafrina Dishti and result in our mock trial. Are you ready to learn it prosecution?
Yes, Your Honor.
Are you ready to learn it defense lawyer?
Yes, Your Honor.
May I proceed to introduce the mock trial group members?
Sure, you may proceed.
Good evening, Your Honor and audience. My name is MD Ariful Islam chowdhury and I am the prosecutor in this case and I am also the chief leader in our mock trial group. Thank you, Your Honor.
Good afternoon. I am Shahbaz Khan. I am a defense lawyer of this case.
Good evening, I am Yasmin Jahan and court officer in our mock trial.
Hello, everybody. My name is Moniur Hossain. I am a accused person in this case.
Good evening, my name is S. Sarasel. I am the plaintiff of this case.
Learned prosecution, are you ready to submit production report or praying opening statements?
Much obliged, Your Excellencies, Your Honor. Your Honor, this case is the State versus MD Moniur Hussain and others. This case is very critical case for us. Your Honor, the prosecution counsel when see the case fact, that time the counsel is feeling very ashamed in this case fact. Your Honor, the case fact is my client's MD Shojib Ahmed is a driver of Bangladesh Welfare Board. Your Honor, that allocated car registration number is Dhaka Metro Law 029193. When my clients park his allocated car in front of nearer Ramna Thana police station at Shegun Bagicha, in the date 29 September and time of 2 p.m. That time, Your Honor, suddenly the offender who has presented the code, which consists 3 men, but unfortunately the presenting offender arrested by the police officer. Your Honor, the offender Mr. Moniur Hussain, son of Karimullah, has burned my client's allocated car, but unfortunately, Your Honor, that time the presented people of that position and the police member red-handed this offender. Your Honor, the counsel is already said that this offender which consists with 3 men. Your Honor, the offender created very serious offences. This is the violation of the Crimes Act. The offender person already said they are consist with 2 men, 2 persons. Their name is Mr. Joy and Mr. Iqbal Hussain, who has already escaped. That's why, Your Honor, this is counsel think that offender is serious for us, that an application for the repetition Therefore, it is humble prayer that under section 496 to 502 of the Code of Criminal Procedure, that Your Honor would graciously be pleased to order for rejecting of the bail petition and order of the remand petition. Prayer in proper law. That's all, Your Honor.
Learned defense, are you ready to submit your production report or praying opening statements?
Yes, Your Honor. Must oblige Your Excellence. The defendant stands here falsely accused of law and order disruption crime, a very serious crime. Your Honor, in this case is about a person who mentally ill and didn't know what he was doing. He was suffering from diminished capacity and perhaps committed a crime but just not that crime that the prosecutor alleges. That's I want to discharge the petition, remand petition, and I want to bail. That's all, Your Honor.
Order. After hearing the both sides, the prosecution and defense logically arguments and submitted their copy, the court decided that the accused persons are arrested by the police officer. So the court rejected the bail petition and granted remand 4 days remand to the case under section 4(5) of the Law and Disruption Crimes Speedy Trial Act 2002. The court is adjourned. The court in the session will be start on the date 2012-2015.
The audience, the court is suspension.
Chief Group Leader MD Ariful Islam Chowdhury. He has gotten VC and Dean Certificate 2014 to 2015 for his brilliant success. He was elected Treasurer of Law Club Election 2015. He has successfully completed his every semester group field visiting as a group leader. He has also attended Leadership Workshop 2015 as a Treasurer of Law Club. And he also attended 2015 Bangladesh Student Protest Meeting on No VAT on Education. So, please, all of the students of Green University and faculty members, please pray for him.
Dear audience and jury, our honorable judge is coming.
Sit down, please.
Dear jury, the case number is 12. Now our session is opening.
Are you ready to learn the prosecution?
Yes, Your Honor. Much obliged your excellencies, Your Honor. In this case, the State versus MD Monir Hussain and others, the police officer completed his investigation and submitted the charge sheet in this court. Your Honor, here is this charge sheet. The investigation police officer also selected the name of the accused person. Your Honor, it is our submission to this case charge sheet copy. Your Honor, the investigation police officer already mentioned named accused person who is Mr. Monir Hussain, son of Mr. Hakimullah, then Mr. Joy X and Mr. Monir X, son of Mr. Iqbal Hussain. And Your Honor, they are always involved the offences under the Law and Order Disruption Crimes Speedy Trial Act 2002. Under section 4 and 5, who has mentioned the investigation officer in this case. Your Honor, the police investigation officer also included many evidence in this charge sheet copy. Your Honor, I will argue on we submit that there are some grounds to take cognizance. There is this charge sheet under given below, such as the investigation police officer already mentioned his investigate charge sheet report the accused person to fulfill the further on 29th September, and the accused person are already known this task who has done themselves, and the accused person are arrested to the police officer. So it is most humbly prayed that Your Honor would be kind enough to get cognizance the statement of the petitioner, which has been taken under section 4(5) of Law and Order Disruption Crimes Speedy Trial Act 2002. That's all, Your Honor. Thanks our audience.
Yes, defense lawyer.
Yes, Your Honor, must oblige Your Excellence. Your Honor, the state has claimed that they have an eyewitness who identified my client throw the petrol bottle into the car. However, this supposed witness really has poor vision. He was far away from the occurrence place to see the crime. The state has also claimed that my client confessed to burn the car. However, my client was captured and threatened by the police. Your Honor, my friend prosecution lawyer submitted his remand petition, but I want to submission my narrative petition against the remand petition so that my client have discharge of this crime. That's all, Your Honor.
Order. After hearing the both sides, the prosecution and defense logical arguments and their submitted copy, the investigation officer sent the court in this case to the charge sheet. So the court decided that offender are involved this case. Related crimes, so the court this charge sheet granted by the cognizance. Under section 45 of law under disruption crimes speedy trial act 2002. The court is adjourned. The court is the session will be started on the date 21/12/2015.
The audience, the court is suspension.
Our respected Mr. M.D. Shifatullah and respected Chairman Mr. M.D. Abunaim Miyaji always cooperate our group very attractively. Our course instructor is very honest and respected person in our department. So, all of the students of GUB proud of Mr. M.D. Shifatullah. Sometimes he is our parents, guardian, and he is also an ideal teacher. This mock trial has fulfilled completed by his cooperation and instruction. So, our group member and also me as a chief leader especially thank our honorable teacher Mr. M.D. Shifatullah.
The audience and jury, our honorable judge is coming. Dear jury, the case number is 12. Now our session is opening.
Prosecution lawyer, are you submitting any evidence report or documents?
Yes, Your Honor, must oblige your excellences. In this case, the state versus M.D. Munir Hussain and others, the prosecutor submit petition for framing charge. The prosecutor submit petition for framing charge. For this reason, Your Honor, the prosecutor already mentioned that the police investigation report details and others report the offender already arrested by the police officer. This offender also gave many information for the other offenders by the prosecutor remand petition. Your Honor, when we will see the Caesar list report, the investigation officer already mentioned that attachment document. Your Honor, this Caesar list report. Your Honor, my client's car, Dhaka Metro Law 029193 already fulfilled have been destroyed. Your Honor, this council already proved that this offender created these crimes under Section 45 of the Law and Order Disruption Crimes Act, Speedy Trial 2002. Your Honor, the accused petitioner already known his task, who has done themselves. So, it is most humbly prayed that Your Honor would be kind enough to order charge frame of the petition and the petition of charge framing in proper law. That's all, Your Honor.
Defense lawyer, can you submit any documents report?
Yes, Your Honor, must oblige Your Excellence. My friend, prosecution lawyer, submission his charge frame, but against this submission, I want to submit discharge petition. an application for discharge petition on behalf of the accused petitioner. The humble petition of the above named accused most respectfully states as follows: that the accused petitioner is not named in FIR and has been arrested by the police out of suspicion, that the accused petitioner was arrested by police and was taken in the police remand. From the police remand, nothing was recorded, that there was no conventional statement of the accused petitioner under section 164 of the Code of Criminal Procedure, that the evidentiary materials on record do not make out a prima facie case against the accused. So, wherefore, it is most humbly prayed that Your Honor would graciously be pleased to enlarge the petitioner on this just petition on such condition as Your Honor deem fit and proper, and for this act of your kindness, the humble petitioner as in duty bound shall execute. So I submission my this petition. That's all, Your Honor.
Order. After hearing the both sides of prosecution and defense arguments, the court decided that the defense are not fulfilled, mentioned that his client are not fulfilled involved this case, so the court reject the prosecution discharge petition under section 239 of the CRPC. And the court could charge framing under section 45 of Law and Order Disruption Crimes Speedy Trial Act 2002. The court is adjourned. The court is the session will be start on the date of 22/12/2015.
Your audience, the court is suspension.
Chief Group Leader MD Ariful Islam Chowdhury. He has gotten VC and Dean Certificate 2014 to 2015 for his brilliant success. He was elected Treasurer of Law Club Election 2015. He has successfully completed his every semester group field visiting as a group leader. He has also attended Leadership Workshop 2015 as a Treasurer of Law Club. And he also attended 2015 Bangladesh Student Protest Meeting on No VAT on Education. So, please, all of the students of Green University and faculty members, please pray for him.
Dear audience and jury, our honorable judge is coming. The court is now at session.
Sit down, please.
Dear jury, the case number is 12. Now our session is opening.
Are you ready, prosecutor?
Yes, Your Honor. To all of you, ladies and gentlemen of the jury, again my name is MD Ariful Islam Chowdhury and I am a prosecutor in this case. In our last session, I mentioned that the accused person are fulfilled guilty under the Law and Order Disruption Crimes Speedy Trial Act 2002. But at this time, I mentioned that I would call two witnesses to testify as to the accused person are guilty. Your Honor, I would call prosecution witness Mr. Joy X.
I will tell the truth.
I will tell the truth.
The truth will not lie.
The truth will not lie.
Hello, Mr. Joy X. How are you?
Fine.
Do you know this person?
Yes, I know this person.
Please, honestly speaking, when this person is known to you?
When the person offers comment, I don't know this person.
Okay, that's all, Your Honor.
Defense, you want to proceed the motion?
Yes, Your Honor. Much obliged, Your Excellence. I want to ask some question to Mr. Joyex. Hello, Mr. Joyex. How are you? So you are the witness of this case.
Yes.
Is your eye vision is really good? When the crime is occurred, in that time, what are you doing?
4 p.m. afternoon.
Okay. But you say that you saw my client to throw the petrol bottle in the car.
Yes.
But I know there is 2 motorcycles there. So why you shoot that my client throw the petrol bomb?
Yes.
No.
Yes.
So yeah, you see me?
Yes.
There?
No.
No. So there you are away from 300 yards maybe. You don't see me 100 yards away. Then why you saw 300 away, Mr. X?
Yes.
No.
Yes.
Your Honor, there is much confusion of this case. The witness is not sure about the crime. So it's my humble prayer to say that my client released. Thank you. That's all, Your Honor.
Prosecution, you want to re-examination?
Yes, Your Honor. So, Mr. Joyex, after all, we can say that this accused person are guilty in this case. Yes or not?
She is guilty.
That's all, Your Honor. She is guilty.
Defense, are you want to discuss logically your witness or evidence?
Yes, Your Honor. I want to ask some question in this case. The second witness, Mr. X, please.
I will tell the truth.
I will tell the truth.
The truth will not lie.
The truth will not lie.
You are a witness of this case. When the crime is occurred, you are there.
Yes, I'm there.
What are you doing in that time?
The time I sit a tea stall to drink tea.
So, do you know him?
No.
Do you see him before?
No.
No. He is the accused person of this case. When the crime is occurred, there how many motorcycle is there?
2 motorcycles.
So one witness said that he saw my client to throw the petrol bottle. Are you sure about this?
No. I saw 2 motorcycles come and throw the petrol bomb and go away. But this person I didn't see.
Thank you, Mr. Joe.
Prosecution, you want to cross-examination?
Yes, Your Honor. So, Mr. Joy, that time what are you doing?
I'm sitting in a tea stall and I drink tea.
This person is accused? Yes or not?
No.
But how? This person is arrested by the police officer.
I didn't see him
Police
there.
officer.
I didn't see him there.
So I want to say that this person is arrested by the police officer. Why? Why it's possible?
I don't know, but I didn't see him there.
That's all, Your Honor. I have already fulfilled mention that this person is already arrested by the police officer. So the prosecution think that this person is accused person. That's okay.
Defense, are you want to re-examination?
No, yes, Your Honor. But I have some argument of this case. Your Honor, the prosecution has explained that witness saw my client to throw the petrol bomb into the car. But prosecution didn't say is that my client suffers from mental illness. He was literally out of his mind that day in question, and we have an expert witness who will testify that my client is insane. Your Honor, the prosecution will call 2 witnesses to the start. First will be say that he saw my client to throw the petrol bomb, and but he was long far away from there. And the second witness say that he was my client on a bike, so he didn't sure about this, that my client threw the petrol bomb. That's all, Your Honor.
Prosecution, are you want to argue your witness or
Yes,
evidence?
yes, Your Honor. Your Honor, the prosecution is this case. In our last session, I mentioned that our learned defense lawyer are very confused in this case, and this person is accused in this offense. That's why the prosecution submit two evidence. This situation picture, and the prosecution submitted this fingerprint to accused person. The prosecution submitted this photo under this section 4 of the Law and Order Disruption Crimes Speedy Trial Act 2002. And lastly, Your Honor, the prosecution submit the scissor list copy and fingerprint copy which was matched this offender. Your Honor, the prosecution, we always testified and we have always established the following facts are true of this offender. And this offender intentionally struck my clients and my client's car. This offender acted without self-defense. So we should ask if the reject the defense theories of the case. And lastly, the prosecution say that this offender are guilty to the case. That's all, Your Honor.
Order. After hearing the both sides, the court decided that the judgment of this case announced on the date of 23/12/2015, the court is adjourned.
Dear audience, the court is suspension.
সবুজের বুকে জেগেছে সবুজ দূর হলো আধার
আলো পেল সকল অবুঝ
জ্ঞানের আহ্বান
নবীনের প্রাণে প্রাণে বেজে ওঠে এক সুরে
গ্রিন 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 ইউনিভার্সিটি
Dear audience and jury, our honorable judge is coming. The court is now at session.
Sit down, please.
Dear jury, the case number is 12. Now our session.
Offender, are you offender or innocent? Any doubt about you? Yes or no?
Yes.
Order. Final judgment. After hearing the both sides, the prosecution and the defense logical arguments and their submitted as evidence copy, the prosecution lawyer are successfully mentioned all. The evidence and report of this case, the prosecutor arguments are logically and mentioned the law of this case relevant act. Other hands, the defense lawyer are not fulfill mentioned any evidence, witness, reports according to the law. But the court are clearly section about the investigation officer report and other documents of this case relevant. So their evidence, so their audience in our book and the learned person, the court decide that the offender are guilty of this act. So according to section 4 and 5 of the Law and Order Disruption Crimes Speedy Trial Act 2002, the state versus the minor Munir Hussain and others, the court judgment favor of the prosecution of the state. The offender punishment imprisonment to 5 years and the fine is 2,000 taka. And the other offenders who are not arrested to the police officer, so they have a same punishment. The court is adjourned.
That's all, Your Honor.
That's all.
Good evening, everybody. Thank you all. Thank you especially to my prosecution lawyers and defense lawyers and judges. Dear audiences and viewers, I am fortunate to have such a nice team to show up such a nice mock trial. In my opinion, mock trial is very important for law students because law students studies law to be a lawyer. Their dream is to be a lawyer, and to be a lawyer is not matter of one day. It's a matter of procedure. It's a matter of day after day. It's a matter of practice. So the practice shall initiate from their student life because study law is not only theoretical subject. It is more than theoretical. It's a practical subject. And practice inaugurates by practicing trial, practicing the argument, practicing the lawyership, practicing the judgeship. So I especially thank this team. They run such a nice mock trial. They show a real good scenario. Whenever I was seeing their mock trial, sometimes I forget I am observing a mock trial. I thought that I am in a real court, and however, I think they have some procedural mistakes. But I think day after day, by their practice, they will improve their rules and procedures, and they will be a best lawyer of Bangladesh. I think by the passage of time, I will see them in the Supreme Court as an established lawyer. Some people, I will see them in the seat of the judge of the different courts of Bangladesh. Best wishes for all my mock trial participants, and best wishes for you all. Thank you.